Welcome back, students, to our explainer for page 2 of Lesson 1, Module 7. Today, we're building directly on the foundation we laid in page 1, where we introduce the general concept of presumptions. In this lesson, we're going to methodically examine rebuttable presumptions in Ugandan law. Go ahead and get your notebooks ready. I'll be pacing this deliberately so you have plenty of time to capture all the key definitions and those all-important statutory references.
Okay, let's dive into this. Here's what we're going to cover today. What are rebuttable presumptions? The shifting burden of proof, 5 key Ugandan presumptions, presumptions in legal practice, and finally, a discussion on the estate dispute. Section 1. What are rebuttable presumptions? So what exactly are we talking about here? Well, a rebuttable presumption is a presumption that the law allows, but, and this is key, that the opposing party can challenge and displace by adducing sufficient contrary evidence. The absolute operative word to underline in your notes right now is rebuttable. It literally means it can be pushed back against. It operates unless and until it is successfully challenged with sufficient evidence, at which point the court just decides the issue based on the actual facts. Moving on to Section 2, Shifting Burden of Proof. And this brilliantly illustrates the procedural flow in the courtroom. When a rebuttable presumption is invoked, it actually shifts the evidential burden. It's kind of like a ping-pong match. In Step 1, the party favored by the presumption holds a massive advantage. They don't even need to prove the presumed fact. The law does all the heavy lifting for them. Then, in Step 2, the ball is in the other court, and the burden shifts entirely to the opposing party. They must adduce evidence to rebut that presumption. If they succeed, we reach Step 3, where the presumption completely falls away and the court decides the matter based purely on the weight of all the evidence presented. However, you should note that not all rebuttable presumptions are created equal. The standard of proof required to actually break them varies quite a bit. Some are relatively fragile, meaning they can be displaced by almost any contrary evidence. Others, though, are incredibly robust, requiring the opposing party to provide solid proof on the balance of probabilities. That standard always depends on the specific governing provision in the law. Section 3. 5 key Ugandan presumptions. All right, let's look at some specifics. First up is the presumption of death. Write down this authority. Section 107 of the Evidence Act, Chapter 8. I'll say that one more time. Section 107 of the Evidence Act, Chapter 8. This section provides that when a person has not been heard of for 7 years by those who would naturally have heard of them if they were alive, the law presumes that person is dead. So how is this rebutted? Simply by producing evidence that the person is, in fact, alive. Let's move to and see how this builds our understanding of family law. Our second concept is the presumption of legitimacy. Under this, the law presumes that children born during a lawful marriage are the legitimate children of the husband. Now, the burden is entirely on anyone who wishes to dispute this. To rebut this presumption, the opposing party must provide concrete evidence of non-access to the wife during the period of conception. Next, our third concept is the presumption of regularity. This rule dictates that acts done in an official capacity are presumed by the court to have been done properly and regularly. For example, if a government official stamps a document, the court just presumes the proper procedures were followed. To rebut this, a party has to bring forward specific evidence of irregularity or unauthorized improper conduct. Now, what's really interesting about this slide is how it applies to criminal defense. This is our fourth concept, the presumption of sanity. The law presumes every single person is sane until the contrary is proved. The statutory authority you need for your notes here is Section 11 of the Trial on Indictments Act, Chapter 25. Section 11 of the Trial on Indictments Act, Chapter 25. This presumption explains exactly why the defense of insanity places such a heavy burden on the accused. The presumption operates against the defendant. Therefore, it's the defendant who must rebut it by proving their own insanity, and they must do so on the balance of probabilities. Our fifth and final key presumption is the presumption of continuance. Essentially, a state of affairs proved to exist at a particular time is presumed to continue until the contrary is shown. So if you prove a certain condition existed on a Tuesday, the court is going to presume it still existed on Wednesday unless someone provides actual evidence that things changed in the interim. Section 4. Presumptions in legal practice. So the crucial point is how these map onto specific everyday areas of legal practice. In succession, for instance, the presumption of death is absolutely critical. You simply cannot administer a missing person's estate without it. In family law, that presumption of legitimacy arises regularly during bitter inheritance disputes. And over in later law, the presumption of regularity is constantly at play. Think about certificates of title.
They are presumed to be correctly issued until someone brings compelling evidence of fraud or irregularity to rebut that.
Section 5. Discussion. The estate dispute. Let's put all of this into practice with a legal puzzle for you to solve before next time. A man dies in Uganda, leaving an estate. His widow from a civil marriage claims the estate, but suddenly a second woman appears claiming she is his wife from a customary marriage. The first widow invokes the presumption of legitimacy for her children to secure their inheritance. So using the framework we just walked through, I want you to analyze both positions. What specific presumptions arise here, and procedurally, how exactly can each be rebutted? Review your notes on the shifting burden of proof and come to our next session ready to argue this case. Thanks for your focused attention today, and I'll see you all next time.